This is Sheikh Asif Salam from Salam Immigration and Salam and Company Solicitors Limited. I just wanted to share with you a case study. We had a bail application today. This was regarding a European national who was convicted and sentenced for nearly 3 years and was detained by the Home Office after he had done half of his sentence. As you know, after half of the custodial sentence, the probation may release a person on license so that they can spend the rest of the period of sentence at their home, and if they don't breach any of the conditions of that license, they can spend the whole of the balance half at their home. But what happens is, if the Home Office want to remove someone from the country on the basis of them being not good or not conducive to remain in the country because of their criminality, so they call it that you may be a problem with the public security, so that these are called grounds of public security. So on grounds of public security, if they want to remove someone, they would not let that person go out free from the prison, and they would take him to the detention center straight from the prison and keep him detained till they have settled his removal, or if he has an appeal, if he wins the appeal, then they would let him go. So when someone is detained in such situation, he has a right of appeal, because he does have a right of appeal. If they want to remove him, he has the opportunity to present his case to a court, which is called the Immigration Tribunal, that he is not one who poses any issues of public security, or that he is protected by the law from being removed because of his length of residence in the UK. In this case, this gentleman has been here for more than 10 years, and therefore his removal would have been very difficult for someone who is a European and who has lived in the UK for 10 years prior to the sentence or prior to the imprisonment, can be removed only on the grounds of public security, if that is like an imperative ground. It has to be a very high threshold. They call it on imperative grounds of public security. So the threshold is the highest, and in most of the cases people are protected if they have lived for so long in the UK. Like the Home Office's own guidance says that this would be in situations like, for example, if someone is a member of an organization or an organized gang selling drugs. So it's not just an individual, it is someone who is part of an organization doing crime on an organized basis, on a large scale basis. So that is something which will still be hit. Below that would not be hit. So the bail was granted. Fortunately, for grant of bail, they also have to see whether or not he meets the other criteria. Like, as I've said, the removal may not be imminent because he is protected. Then does he have an appeal? Yes, he had an appeal pending. So because of that pending appeal, there is scope for his release. Then it's important to see that someone has family ties, a stable home to live in, so that because of these links and place of abode, he would have less incentive to become a fugitive or disappear. And if someone has been complying with the bail conditions like reporting, then there is no need for someone to be put in a detention center. Rather than he can simply be asked to report every week or every month. If he is good at reporting in the past, why would he not report now? So he should also have some sureties who would say, if he does not comply with the bail conditions, we commit to X number of pounds, say £1,000 or £2,000. Normally there are two sureties. So the sureties should be British citizens or European citizens with a job or a good financial standing. So if all that is available, then detention is not the answer to make sure that the person does not keep in touch with the home office. So I hope this is useful information if that is relevant to your case or the case of anyone that you know of. Thank you very much.